Good afternoon. No, I did not forget to click go live, and I did not put in the wrong time. I started the stream, and then I had to do something real quick. And I might have to go and do something again real quick. But so let's start recapping. Let's go over some things. No, sir, I'm not wearing pants. Actually, I am. It's kind of chilly out here, but what are you going to do? So we're gonna start off. We're gonna go over some of these cases. This is Decastro versus Las Vegas Metropolitan Police Department. We had already gone over the motion to dismiss. There was another order, a minute order in chambers. There was a motion to strike. Chile had moved to strike the defendant's answer, and that was denied as moot. So that is what is going on with that particular case. The next case that we are going to look at is Wallace. Wallace has had some stuff going on. There was apparently some confusion on it. There were some comments on it in my Discord today. The first thing is that on the 23rd, the court ordered the defendants Torres, Shoemaker, and McCormick to lodge the manually filed exhibit with the court by November 1st. Way back when, on August 23rd, they had filed a notice of manual filing. They had filed a motion to dismiss. Where was their motion to dismiss? That's Metropolitan Police Department. Oh wait, this was by LVMPD. So here we go. Here's the motion to dismiss, and then they did a motion for manual filing of an exhibit, a CD-ROM containing video. I'm assuming it's going to be body cam footage, and that was filed on that was done on September 1st. So the court got around this week on October 23rd to order them to file it by November 1st, which is probably moot at this point because on the 25th, let me do this so that I can see if you guys are asking me questions or if you need further clarifications. The chest herpes still getting you? Yes. That's a great question, WTT. It is, in fact, gay time. What's good? I don't know. I only know it's bad. Yeah, there he is. Gay. Yes. Good afternoon, Alan. Denied, dismissed, and mind dismissed. Denied, dismissed, to mind dismissed. Okay. It's going great. And I'm having a chelada, mango y chile. Delicious. Delicioso. Oh no, drinking on camera. This is going to get my stream demonetized. Paige has been waiting. Keep waiting. You're on the list. Nice. TikTok. And fix your hair. Someone posted a video about Paige volunteering to show her boobs or saying she was going to show her boobs on the stream or something, and she never has. So I'm going to call her a liar. You're all on the Stay Bent Over list. Nice. Brought a new brush. Okay. Queuing board. Good job. Dang, everyone wants to be on the list. Anybody watching this on mute with porn playing on the other tab? No, just me. Just me. What's the gestation period for your babies? Oh, they hatched. So the eggs hatched. Apparently my male bristlenose had been sitting on a clutch of eggs. He's got a little cave he could hide in, and he traps the female in there, and then she squeezes out her eggs, and then he goes in there and fertilizes them, and then he kind of chills with them until they hatch. And they hatched, apparently, because I've got a whole bunch of babies all over the tank. So there's that. Paige B is beautiful. Well, she has big titties, which goes a long way. Was a dismissed motion early July. Thank you. Hello, Murby. I hope all's well. Well, all is great. Thank you. Nate wants to get a margarita and retarded comments indeed. So the next thing is the voluntary dismissal. Now, this was filed by Wallace, wink, Wallace. And he says, I, plaintiff, hereby notify the court and all parties of my voluntary dismissal of this action against defendants Torres, Shoemaker, McCormick, and Does 1 through 50, inclusive defendants pursuant to Federal Rules of Civil Procedure 41A1AI. So he is correct. He can do it. It is voluntary. Thank you, Alan. It is voluntary. He can do it without an order of the court. So, like, to this point, he's A1. Good job. He's on the ball. Then he says, the defendants have not filed an answer nor a motion for summary judgment, and I have an absolute right to voluntarily dismiss this action without prejudice. Sure. Yeah. Sure. Sorta. Sure. You have an absolute right to dismiss the action. I don't know if you have an absolute right to dismiss it without prejudice. I don't think so. He goes on to say this case will be refiled and the defendants are on notice to protect any relevant evidence. Now, the problem is with that is I always get these backwards and mixed up. So don't quote me on this. I'll give you the idea, maybe not the correct verbiage. But there's issue preclusion and claim preclusion. And one of them is when you actually litigate a particular set of facts. Like say for example, two people attack you. They both attack you at the same time. And you get injured from them attacking you. You don't know which bruise was from person A. You don't know which broken bone was from person B because they both attacked you, right? So if you sue one of them, just one of them, and you litigate that to conclusion, you're barred from taking that action up against another person. I hear you, brother. I hear you. Brings a tear to my eye. So that I think that's issue preclusion. Because there's been someone on the other side who's basically had the same interest in litigating those particular points as you would, right? So the issue with this is that he can't have multiple cases. He can't split the defendants in this into multiple lawsuits because they're all tied to the same nexus of events. So that doesn't make a whole lot of sense to me, but the court may let him do it, may not. Well, the court I think has to. I think the court has to let him dismiss it. But if he refiles against Torres, Shoemaker, and McCormick, then I believe they can raise the issue of, I think it'd be issue preclusion, but it might be claim preclusion. I get the terms mixed up, so I'm not going to take the time to look it up. So he totally can do that. It doesn't dismiss the entire case, though. And then we have the order denying as moot all this stuff. So, you know what? Let's just do this because then I can make it big. And I know how you ladies love it when I make it big, and some of you boys. Nice. All right. So this is the order, the order of the court. And I think this is going to be probably, this is actually the district judge, not the magistrate. Okay. All righty then. So plaintiff Wallace sues the LVMPD and 3 LVMPD officers for various claims arising out of an incident where the officers detained, searched, and arrested him. LVMPD moves to strike Wallace's complaint because it contends it was ghostwritten by non-lawyer Jose Decastro. I believe that they're going to win on that. They should win on that. LVMPD also seeks to preclude Decastro, who's not a party in this case from practicing law without a license. I don't know. I don't think they'll win on that. I didn't recall that. I thought they just wanted him to not be able to. No, the striking, they're not going to win. I thought they didn't want him from practicing law in this case without a license. Interesting. Interesting the way the court framed it. That's interesting the way the court framed it. So they should lose on the motion to strike. The court framed that differently. Well, I would have said that they would have won on this, but now that I'm reading it, I'm going to retract. I think they will not win on that. In response, Wallace moves for an extension of time to respond to the motion to strike and for sanctions under Federal Rule of Civil Procedure 11, contending that LVMPD had no basis for its motion to strike. I think he will lose on that, on the contentions that LVMPD had no basis for a motion to strike. He also moves for an extension of time and for leave to file excess pages in his reply brief on his motion for sanctions. Since the court's ruling on it, I'm thinking he's going to deny that. I deny LVMPD's I thought they would have said yes. I deny LVMPD's motion to preclude Decastro from practicing law without a license because Decastro is not before me in this case and has not been served with the motion. Oh, that's an oopsie fucking doodles. That's an oopsie fucking doodles. But see, the way the court framed it is different. I saw it as they were trying to preclude Decastro from practicing law in this case. And there already is a rule of court preventing him from practicing law in this case, i.e., you have to be admitted to the Nevada bar, the Nevada District Court. They have their own bar. The Federal District Court has its own bar. And in order to get access to that bar, you have to be licensed to practice in the state of Nevada. So I would have suspected that the court would have granted that motion, but the way the court phrased it, that's different. Interesting. I deny LVMPD's motion to strike because there is insufficient evidence that Decastro wrote the complaint or other filings in this case to support that relief. I expected the court to deny the motion to strike. I deny the motion is moot. Wallace's motion for extension of time to respond to the motion to strike. I expected that. I deny Wallace's motion for Rule 11 sanctions because there is a factual basis for LVMPD's motion to strike. I expected that. I denies moot Wallace's motions to extend time and for leave to file excess pages. Motion to preclude. LVMPD moves to preclude Decastro from practicing law without a license based on LVMPD's suspicion that Decastro wrote Wallace's complaint in this case. Is that actually what they moved for? Oh, you're not seeing any of this. Jesus fucking Christ. No, not a single one of you. None of you are watching this. None of you are watching this. You bastards. You bastards. You're just listening to me sputter and not helping me out by telling me that my shit isn't right. And we're going to go to, that was ECF number 10. Because he's changing the way they phrased it, I believe. The court is. Which the court can do because, you know, it's the fucking court. Thanks, Papa Sanser. I appreciate it. Nice cover. All right, let's see what we got here. Oh, they did phrase it broadly, and they didn't serve him. What retards? What retards? They should have personally served him. So this, that's what I remember. So I'm surprised that the court completely discounted the, at a minimum, the court should issue an order prohibiting Decastro from participating, assisting, or providing legal advice to plaintiff in this case. I'm surprised the court did not grant that. We're here to pack shit, not correct shit. Nice. Nice. Packing stool. All right. So where were we? Okay. So, however, DeCastro is not before me in this case. He's not a party, and LVMPD did not serve DeCastro with the motion, which he should have. They should have. That's a big oopsie doodles. He therefore had not. He therefore has not had notice and an opportunity to be heard, saying that this procedural due process requires a court to provide notice and an opportunity to be heard before imposing a sanction. As a result, I deny the motion. But see, is it really a sanction? See, I don't even know why the court's phrasing it that way. There is already a local rule prohibiting people who have not been admitted to the Nevada District Court bar from practicing law in the Nevada District Court. So I don't even know why the I don't know. Doesn't make a lot of sense. Motion to strike. LVMPD moves to strike the complaint based on its contention that the complaint was ghostwritten by Decastro. Although there are marked similarities between the complaint in this case and the case Decastro filed in this court that may be indicative of copying rather than ghostwriting. The fact that Decastro plagiarism, according to Wallace, right? The fact that Decastro allegedly admits in various videos that he is assisting Wallace in maintaining this lawsuit does not mean he is writing Wallace's filings. However, I have I have confirmed with the clerk's office that LVMPD is incorrect in its assertion that Wallace is using Castro's electronic filing privileges. Interesting. Wallace is not electronically filing; rather, he's emailing PDF documents to the clerk's office, which is then filing his documents on the docket. I did not even know you could do that. I did not even know you could do that. Well, as an attorney, I have to e-file because the court is rude like that. But I thought that as a pro per, he had to, unless he got e-filing privileges, he had to file by mail or in person. So that's interesting. I did not expect that. That's unexpected. That's Well, it's interesting. Everybody was so certain. Myself included. Oopsie fucking doodles, right? Mea culpa. I thought that they were right that Decastro was electronically filing it for Wallace because I did not expect that you could do that. So, my apologies to you, Chili, for incorrectly alleging that, or incorrectly believing, I guess. Technically, I was reading someone else's allegations, but my apologies for spreading allegations that were apparently incorrect, that you were e-filing these things for Wallace. Learn something new every day. However, I caution Wallace that he may not rely on a non-lawyer to ghostwrite his filings in this case because it is illegal. I agree. Because it is illegal for a non-lawyer to engage in the unauthorized practice of law. A person engages in the practice of law when he makes a judgment regarding the legal sufficiency of instruments and the drafting of any instrument, simple or complex. The practice of law includes activities calling for the exercise of trained judgment in applying the general body of legal knowledge to the specific problem of a client and recommending a course of action. Although I am denying LVMPD's motion at this juncture, if I later determine that Decastro, according to the State Bar of Nevada's website, Decastro is not a licensed attorney in this state, or any other non-lawyers ghostwriting Wallace's documents, I may strike those documents in this case. See Henry versus Rizzolo. Moreover, the person engaged in the unauthorized practice of law may face criminal penalties. Although the federal district court, this judge would not be able to convict anyone of these state criminal statutes. So at best, she could probably, or he, I think the judge is a he in this, can refer this, like maybe do his own sanctions and then refer it to, or suggest that a DA take it up. Because, yeah. Question: why wouldn't it show up in the ECF as a clerk entered, though? I don't know. To see, I have seen them entered or see them show up as clerk entered, but his never did. So that it might be just one of the quirks. Excuse me. It might be a quirk of the Nevada District Court's clerks that they may not do that. That's all I can say. I don't know. I mean, I've seen them show up as clerk entered before. I've never seen that. I've never seen it done the way that Wallace was, or Chili, whatever, was doing it. Yes, yes, you are. But everybody's entitled to make a bad mistake. Just ask Irish Demon. He made the same mistake twice. So either he's hard up, or she's really good in bed, because she's not good looking. So I tend to lean towards hard up, because have you ever looked at the man? All right. So motion for Rule 11 sanctions. Wallace moves for Rule 11 sanctions against LVMPD and its counsel for filing the motion to strike the complaint. Wallace contends that LVMPD had no factual basis for claiming that Decastro wrote Wallace's complaint. LVMPD responds at a good faith basis for the motion to strike because Decastro admits in several videos he's helping Wallace sue the police, including a video taken when both Decastro and Wallace showed up at a LVMPD substation and demanded complaint forms related to Wallace's arrest. That is at issue in this case. LVMPD also contends that Wallace has been filing documents electronically, even though he does not have permission to do so, and it notes that Decastro has electronic filing privilege in his lawsuit. As stated above, LVMPD's assertion that Wallace is electronically filing his documents through someone else's credentials is incorrect. LVMPD believes that Wallace was incarcerated in Arkansas when the Rule 11 motion was filed, so someone else must have used their electronic credentials for him. LVMPD also notes that Decastro is engaged in the unauthorized practice of law in another jurisdiction. Yeah, it's weird. Maybe since it was already in electronic form in a PDF, it gets classified differently. I don't know. Maybe it's novel to me, but it's not something that I would run into. Is your position that Chili is not writing for Floyd because he nails his motions? Floyd nails his motion? Males, I'm assuming is what you mean. No, I have not. I've not said anything about who's writing what. My belief is that the same people who are writing Chili's motions are writing Floyd's motions. That's my belief. So, but I have no evidence other than having read the documents in both cases to come to that conclusion. So, take it with a grain of salt. The pot called me green. I don't know what that means, but okay. Males, okay. Hey, Jay, Merb the Perv, what's up? Well, same pervy stuff, different pervy day. Here's Merb in living color. Wait till it gets dark. He nailed it. Nails and position. Dirty mind, Michelle. Good point, WTT. I was confused for a second, thinking emails more than likely. Mark Adams is at least helping. That would be my guess, but again, that is just a guess. Floyd is functionally illiterate. Well, not everybody went to the Zoolander school for children who don't read so good. So, Rule 11 requires an attorney or the parties personally, if the party is unrepresented, to sign pleadings, motions, and other papers to certify that to the best of the person's knowledge, information, and belief formed after a reasonable inquiry under the circumstances, the factual contentions have evidentiary support or is specifically so identified will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. I may sanction a party and their counsel for violating Rule 11 B, after giving notice and a reasonable opportunity to respond. I deny Wallace's motions because LVMPD's motion had evidentiary support, or likely would have had evidentiary support after a reasonable opportunity for further investigation or discovery. The complaints in this case and Decastro's lawsuit are nearly identical beyond the core facts of each incident. Compare ECF number 1-1 with Chili's case, ECF number 2. Decastro stated that he would assist Wallace in suing LVMPD, including while standing next to Wallace at a police substation, ECF number 29, manually filed video exhibit. And Decastro has also been found to have likely engaged in the unauthorized practice of law before, ECF number 28 at 19. LVMPD thus had a factual basis for filing the motion to strike, so I deny Wallace's Rule 11 motion. I deny as moot Wallace's motion to extend time and for leave to file excess pages. A passport honeypot? Don't we all want a passport honeypot? Mark is a Chili fanboy. Yes, he is. Again, my assessment of Floyd's reading and writing skills is my opinion. Well, you're entitled to your own opinion. Thai chicks deserve some cultural diversity as well. Well, I'm glad that WTT speaks for Thai chicks. I therefore order that defendant LVMPD's motion to preclude is denied, that their motion to strike is denied, that Wallace's motion to extend time is denied, and Wallace's motion for Rule 11 sanction is denied. I further order plaintiff Wallace's motions to extend time and leave to file excess pages, ECF 30 and 31, are denied. Well, what else do we have here? All right, that was that one. And then we have an order. What is this? Let's just download it. All right. What do we got here? What do we have here? Plaintiff Floyd Wallace filed a notice of voluntary dismissal stating he had dismissed his action against defendants Torres, Shoemaker, McCormick, and Does 1 through 50. Wallace's motion notice is unclear because he states he will refile a new case, but he does not dismiss all defendants. Specifically, he does not indicate whether he also voluntarily dismisses defendant LVMPD. Yeah. See, those are filing a new case. Like you can't have two different cases going over the same nexus of facts. Yes, that is weird. I therefore order that plaintiff Floyd Wallace shall clarify if he's voluntarily dismissing his claims against all the defendants, including LVMPD, or whether he's dismissing only the individual defendants. If Wallace does not... Oh, my bad. Thank you, Laura. Thank you. Laura is a good girl, except when she's bad. And then I hear that she's very, very naughty. Needs spankings or something. I don't know. Some crazy shit. So... There you go. It's not that long, apparently. I therefore order that plaintiff Floyd Wallace shall clarify if he is voluntarily dismissing all his claims, or his claims against all the defendants, including LVMPD, or whether he's dismissing only the individual defendants. If Wallace does not clarify his intent by November 3rd, I will dismiss the entire case against all defendants without prejudice. And the reason why it would be without prejudice at this point is because, well, he intends to refile. Well, hasn't stopped me before. So that is not unusual or uncommon, it's not, I don't know about unusual or uncommon. It's not unexpected that the court would require a clarification of that. Well, I guess it is unexpected. I thought the court would just, the Rule 41 dismissal, the A1AI motion for, or not a motion for dismissal. It's just if they haven't filed their answer or a motion for summary judgment, then the plaintiff can just dismiss them. It's not asking the court for an order. It's just the plaintiff gets to dismiss them. So I kind of thought that they would just be dismissed, and then they would be able, like, basically the court is doing, I think what the court is doing here is the court's doing a solid for Wallace. He's basically saying to Wallace, you're going to have a fucking problem if you try to do things the way you're doing it. So I think the court is actually kind of helping Wallace by saying you're putting yourself in a bad position. If Wallace refuses, can't the defendants demand he pay their legal fees in the dismissed action before proceeding? I don't think so, because they haven't filed an answer or a motion for summary judgment yet. So he can dismiss it at a whim. The issue that he's going to run into is if he goes to refile against them, they can assert issue preclusion or claim preclusion. I forget the technical the term for it. It's some sort of a preclusion, basically saying that no, we would have to be in that case. We'd have to be in that case, and we're not in that case. So you can't sue us because we weren't in that case, and the issue is already decided in that case. All of this work for loser cases. Yeah. But you know what? He has a right to petition the government for redress of grievances. All right, we're going to go back to this one. I think that was the end of it. Yeah, that was the end of it. All righty. So next, we're going to look at our boy. This is Springer versus the 7th Judicial District Court. They do have an appeal pending on the issue of the TRO, solely on the issue of TRO. But that doesn't mean that the entire case stops, because, well, they get to go on. So where were we? So the defendants filed a motion to set aside the default somewhere in here. Here we go. Here's their motion to set aside the default. So the defendants, the judge, Murdoch Poff, Mercedes Murphy, Susan Rosengal, who is, I think, the clerk, and the 7th Judicial District Court have filed motions to set aside. Now, I'm surprised that sovereign immunity, FRCP 41D. Okay, well, we'll look at FRCP 41D for you. FRCP 41. You. If a plaintiff who previously dismissed an action in any court files an action based on or including the same claim against the defendant, the court may order the plaintiff to pay all costs. That is permissive, and may stay all the proceedings until the plaintiff has complied. Now, notice those two things are both may. Now, they haven't filed an answer, and they haven't filed a motion for summary judgment. So it's very early in the case. It is not uncommon to have a plaintiff dismiss a case because they need to correct something, whatever. They filed in the wrong circuit, wrong court, whatever, right? So it's not uncommon. Now, so will he have to? Probably not. I'm gonna go with no. Can't they demand? Well, they can't. I guess they could technically demand it, but will he have to pay? Is probably not. It's probably not. Oh, you can't see any of this. God damn it. So these are the operative words. May. That's the problem. The problem is may. And my understanding of courts is that a court is very unlikely to do it if it's been dismissed at an early stage. They can request, they can demand, whatever, but will the court grant it? That's really what you're asking. Well, that's what I interpret you as asking. I interpret it as you asking for, will the court grant it? Will he have to pay? And the answer to that question is probably not. Almost certainly not. Number one, he was going to proceed in forma pauperis, or he was alluding to be able to proceed in forma pauperis, which means he doesn't have a lot of money. And again, this got dismissed at a very early stage before. I mean, all they would be into it is the cost of. Well, excuse me. Let me even step that one back. The defendants that got their case that Wallace wants to dismiss haven't even paid any legal fees. So what would they be entitled to? You see how this is going all downhill for you, buddy? Um, it's going downhill because there are a lot of reasons why. I know you really want Wallace to have to pay. I know you really want that, and you just have this huge hard on if you can get Wallace to pay. But Marquis Arbach is getting paid by LVMPD, by the city, to defend these officers. So these officers, they're not paying anything. So they have nothing to be recompensed for. Number two, it's getting dismissed early, which means that there aren't a lot of charges anyway. And so the court's going to be very unlikely. Oh yeah, they filed one thing, right? Very unlikely for the court to demand that anybody pay. This is really to stop people from doing frivolous filings. Now, I know you're going to say, because you're jaded and you know everything about Wallace and Chile and how terrible people they are, right? You're going to say that that these are frivolous filings, but this is like real frivolous filings. You saw the court's analysis on whether or not Chile was actually writing the motions for Wallace, right? The court's going to use that same kind of analysis, and that same kind of analysis is going to lead the court to the conclusion that it is not in the interest of justice. Like, this is just something that you practice law long enough, and you just see it coming a mile away. You know, I can't tell you. You're welcome. I'm just kind of riffing off you. I'm pulling at Josh. I'm not like trying to chew into you. I'm just pulling at Josh. You know, I'm pulling at Josh. So all the time, in civil cases like discovery disputes and things like that, all the time you ask for fees and sanctions and stuff. Family law is just rife with asking for sanctions and attorney fees and things like that. It's just super common to be like, oh, you know, you get super litigious and you try to go for all these things, and the courts put the brakes on it. And the courts really look at these things with a like, what is justice really demand? Not based on the facts in the world, but based on the facts directly in front of me that I can ascertain. And what the court's going to look at is the court's going to see that, okay, so in this previous case, well, in this case, the defendants haven't paid anything because the city's covering their defense. But the court, let's assume, arguendo, that they had paid for their attorney. The court's going to look at it and say, well, okay, it's early in the case. This guy withdrew his pleading voluntarily, his complaint voluntarily against them, and then what the court is going to do is the court's going to look at the new complaint that was filed and see what kind of terms that has, and the court's going to take into account that it's a pro per litigant, right? All these things, and it's just very unlikely that anybody's paying anything as far as sanctions are concerned. I mean, you saw me saying like, oh, you know, the LVMPD's not getting their Rule 11 sanctions. I said Wallace isn't getting his Rule 11 sanctions. I mean, this is just so common that like you can see it coming a mile away. All right, so I beat it to death. Ooh, nice. Give me details. Look at the Josh Moon lawsuits. There's some serious frivolous shit in there. Yeah, it has to be serious. If they force people filing civil rights cases to pay for dismissals, it would put a chilling effect on the right to defend your civil rights. You can make an argument for that, sure. Sure. They're really the court. The court is going to look at trying to protect people from having to respond to repeat litigations where it's pretty severe. So, like the one that I thought would actually have a chance of getting some legal fees is the one where Decastro filed against Kate and Josh Abrams, and he filed against them originally for a wide variety of torts, and then he switched it to a specific tort of, well, and then he asked to be able to dismiss it voluntarily so that he could refile it in California, right? So he's broadcast his intention, and then he goes and he changes up his filing, and then he goes and wants to. Well, then he at that point, if he dismissed it and then went to refile it, because there was so much, like, there's so much evidence there of just real bad faith. They've gotten so far into it. They've done multiple motions. They've done multiple OSC's Ray contempt. They've done a lot of stuff. And Kate had accrued a mountain, a fucking shit ton of attorney fees. That's the kind of situation where, okay, the court might be like, hold up. You're doing this in bad faith. And where Chile has specifically stated, I'm doing this to run them out of money. I mean, it's all these things that are going to add up, that are going to make it much more likely that the court is going to order Chile to pay some or all of Kate's fees if he refiled in federal court. Now, you refiled it in state court, and obviously she chose to ignore the case, which isn't unreasonable. I would guess that she is probably judgment proof. I don't think she owns any property, and even if she did, they might have very liberal protections in Massachusetts. I have seen in court videos of people who go pro se. It's PRO and then second word SE, pro SE, pro se. In family cases and landlord cases, the court doesn't make them pay for the other party lawyer's fee. Yeah, that's pretty common. Yeah. Really, unless you're being a dick, even if you're entitled to fees, or even if the other side is entitled to fees, if you're not being a dick, it's hard to get those fees out. For the sanctions based one. Now, if there's some other mechanism, like, if it's contract dispute where there's mandatory attorney's fees for the winner, then yeah, that's different. Yeah. All right. So back to Springer. All right. So they filed the motion to set aside the default. I'm surprised that as a state entity, the 7th Judicial District Court has to respond, but it did. I would assume that state sovereignty would apply to the 7th Judicial District Court. But maybe it's because he's not seeking monetary relief, is he? Let's check it out. There's the complaint. Let's just see what kind of relief he's seeking. Oh God. Here's his prayer. So jury demand, you're only entitled to a jury for non-equity based things. So the court is going to determine the declaratory judgment and any restraining orders, any injunctions. But he is seeking costs and expenses and actual damages. So the actual damages would go to the jury trial. So he's actually seeking money. Okay, so the New Mexico Civil Rights Act must allow for a court to award monetary damages against state actors. Interesting. Just helping you out. Just helping you out. I don't think so. All right, so he is asking for money. All right, so but we also explained why the 7th Judicial District might still be involved. So there was a motion to stay the notice of appeal. I think we covered that. And then the next thing, I think we need to do. So Springer filed the motion or filed a response to the motion to set aside, but the court granted it. I think we've been over that. And so I think where we're at is this stuff here. So first motion to dismiss for failure to state a claim. As to individual defendants and no supplemental jurors, as to state claim by Jason Jones, Poff, Murphy, Rossingall. Okay. So actually, let's download it and look at it. Let's download it and look at it. So there's 2 motions? Interesting. All right. All right. So they're going for qualified immunity, or as they like to say in New Mexico, qualified immunity. Is this the one where they had shit where the defense attorneys just did not spell check shit? Why would it be qualified immunity? Judges have judicial immunity. They have complete immunity for any judicial act. So they come and in lieu of an answer, move the court to dismiss the complaint for declaratory injunctive relief. The action arises from an incident on January 27th where blah, blah, blah. I'm not going to go through this. In count 1 of plaintiff's complaint, plaintiff alleges that a claim under 42 U.S.C. 1983 predicated on violations of First Amendment rights to freedom of the press and speech. Count 2 alleges a claim predicated on substantive due process violations. The court struck these and asked them to combine. Well, then let's not waste too much time on them. That was weird. So, okay, so the judge is not retarded. That is awesome. Thank you, Jasper. All right, so then they did a reply to the response. All right, so this is by James Springer. So this is their reply. So it goes motion, opposition, reply. Sometimes some places call it motion response reply. That doesn't make a lot of sense to me, but okay. So blah, blah, blah. Facts put sufficiently at issue by plaintiff's affidavit. Defendants attempt in their response to mischaracterize the facts and support that plaintiff's affidavit provides is merely dispute over the determination by this court to deny plaintiff injunctive relief. But as the court is aware, plaintiff already has filed an appeal of the right of the order at issue. And while court's overly differential evaluation of the briefing in favor of the defendants is invoked as evidence of reasonable question concerning a bias or lack of impartiality towards judicial defendants, it is but one of several examples. They're all shit examples, by the way. They're absolutely dookie. And, you know, the same court that you're saying gave an overly differential evaluation is the court that you're now in front of to the motion to recuse. In fact, the majority of the examples that give cause to reasonably question Judge Strickland's impartiality were present as referenced in plaintiff's affidavit in support of this motion before a decision denying the injunctive relief sought by plaintiff. Plaintiff does not repeat the facts confirmed by plaintiff's affidavit, but does note that defendants ignore and do not address or explain how the deference reasonably inferred from Judge Strickland's actions is not factually accurate. Because it is inferred, it is not a fact. So that's kind of weird. That's kind of weird. There's an old statement. If you can't blind them with brilliance, baffle them with bullshit. And he is baffling with bullshit right now. In short, plaintiff, through his affidavit, has merely confirmed what the docket shows to be true and what animates the reasonable question of whether or not Judge Strickland has demonstrated a bias towards judicial colleagues from the state court bench. So basically, he is saying that their position was, look, you're just saying that you lost, and that shows bias. You can't just say I lost, therefore bias. And he's like, well, all you have to do is look at the docket, and you can see that they're biased, and it's basically I lost, therefore bias. This is not a run-of-the-mill case where this type of impartiality could reasonable occur, and it is fair, though these defendants clearly take issue with having their judgment questioned, for plaintiff to request review when presented with defendants that were served pursuant to NMRA 1-004 by hand delivering a copy to the defendants at a location where they can typically be found. I thought they handed it to a clerk. I believe they handed it to a clerk. Didn't we already confirm that they handed it to a clerk? I'm going to do this. Save. I reasonably recall them handing it to a fucking clerk. We're on page 2. I recall them handing it to a fucking clerk. Where was their motion to set aside? There we go. Here we go. Jesus, whoever's writing these motions for the defendants needs to get shot. I'm surprised, metaphorically speaking, in Minecraft. I'm surprised that judges would have someone who's writing motions that are this sloppy represent them. Like, these are fucking terrible motions. All right, so they served Rossingall personally and attempted to serve the others, So Rossingall was served personally. They were not served personally, nor at their dwelling or usual place of abode. Neither is Rossingall an agent authorized by appointment or law to accept service on their behalf. The 7th Judicial District Court was not served by delivering a copy of the summons and complaint to his chief executive officer, nor is prescribed by the state of New Mexico's law for serving a summons or the like on state-created governmental organizations. So there were issues. It's not that they're overly obtuse. It's they said the same thing. Like, they laid out an argument And then they laid the argument out again, and I think they laid it out a third time. Like it's not, it doesn't have a flow to it. It's disjointed. They didn't spell check. They have, if I remember correctly, they have sentences that don't make any fucking sense. It's just, and they spent a lot of time talking about setting aside a default judgment. And you're like, why the fuck are you talking about setting aside a default judgment? There is no default judgment. There's only a default. It was very annoying for me to read. So so again, so he is misstating. This is Springer's attorney is misstating that, oh, a hand delivered copy to the defendants at a location where they typically be found. No affidavit has presented. No affidavit has presented by defendant Rosengal. No affidavit has presented by defendant Rosengal that she was not authorized to receive a delivery of copies for the other defendants, or that she did not deliver the copy she received to the other defendants. Well, she doesn't have to. She doesn't have to file an affidavit about that, you dumb fuck. Jesus fucking Christ. You can serve federally. You can either serve by the means that are set forth in the federal rules of civil procedure, or you can serve under the rules of the state. Sorry, thank you. My bad. So you can either serve under the federal rules or the specific state you're in under their rules. Neither of those rules authorized them to just serve one defendant. And because neither rule authorized them to serve one defendant, Rossigal didn't have to say, oh, I didn't deliver it to anybody else. It's fucking stupid. This attorney has not really impressed me, to be perfectly honest with you. None of the people say that I'm too like uppity, but you know, I've produced my fair share of shit legal pleadings. I have. I'm going to be honest with you, but like there are some times where you'd be like, okay, so like this line of argument, it's the only line of argument you have. It doesn't really work, but I can see why you took that line of argument because, well, it's the only line of argument you have. But like, this is just stupid. Like, why would you make this argument? You don't even have to. He didn't even have to argue this. This isn't relevant to anything. This is a reply to the defendant's opposition. All he has to do is pick up what they're saying and say, this is wrong because of this case. This is wrong because of that case. This is wrong because they misstated this fact. This is wrong for this reason. This is wrong for that reason. That's all he has to do. That's all he has to do. And he's not doing it. But it failed to follow the rules of civil procedure, following the complaint service only to have Judge Strickland apparently assume that the issue is with plaintiff's service. But see, when you have to do things like apparently assume, why don't you look at what Judge Strickland actually ordered and the rationale that Judge Strickland set forth to achieve to reach the legal conclusion that he or she reached. To be perfectly clear, the facts that plaintiff confirms in his affidavit, or those of the procedural deference towards the judicial defendants, i.e., excusing without any request or explanation the failure of defendants to comply with Judge Riggs' order requiring a response 14 days after defendants were served on June 21, 2023, or certainly no later than the hand delivery on July 13th, 2023. That sentence doesn't make sense. To be perfectly clear, this is allegedly a sentence. To be perfectly clear, the facts plaintiff confirms in his affidavit, or those of the procedural deference towards the judicial defendants, To be perfectly clear, the facts plaintiff confirms in his affidavit or those of the procedural deference towards the judicial defendants, i.e., excusing without any request or explanation the failure of defendants to comply with Judge Riggs' order requiring a response 14 days after the defendants were served on June 21, 2023, or certainly no later than the hand delivery on July 13, 2023, pursuant to Rule 5b2. That sentence makes no fucking sense. That sentence does not make any sense. That does not make sense. That is quite possibly the world's shittiest sentence. That doesn't make sense. In essence, the evidence supported by plaintiff's affidavit is that appears the evidence supported by plaintiff's affidavit is that appears to be a reasonable assumption that Judge Strickland took on faith that these defendants could not possible be at fault for failing to follow court rules and that it must be plaintiff that is not following the rules. What the fuck? In essence, the evidence supported by plaintiff's affidavit is that appears to be a reasonable assumption that Judge Strickland took on faith that these defendants could not possible be at fault for failing to follow court rules and that it must be plaintiff that is not following the rules. In essence, the evidence supported by plaintiff's affidavit is that it appears to be a reasonable assumption that Judge Strickland took on faith that these defendants could not possibly be at fault for failing to follow court rules and that it must be plaintiff that is not following the rules. That is a shitty sentence. But okay, at least I could get around after reading it like 5 times. I could fill in the fucking blanks to make it make some sense. But my God, is this guy getting paid by the word? This action exhibits either a bias against plaintiff or in favor of these defendants, which is precisely what the law establishes a process for plaintiff to test in front of another district court judge once he is sufficiently, by these facts at issue, in an affidavit. So this action exhibits either a bias against plaintiff or in favor of defendants. Okay, I understand that section. Which is precisely what the law establishes a process for plaintiff to test in front of another district court judge. Once he has sufficiently proven these facts at issues in an affidavit, I don't fucking know. You don't fucking know. No one fucking knows. I mean, am I being hard on this guy? Like, the point of writing a reply like this is to help the judge understand your argument or help the judge take apart their argument. And if the court can't understand your fucking reply brief, you're not helping anybody. However, here defendants misrepresent the law. What Judge Strickland may do is evaluate plaintiff's affidavit to see if sufficiently puts facts at issue that could be evidence that reasonable questions the impartiality of Judge Strickland. First of all, you don't want to start off a new paragraph with however. That's just bad form. Just don't do it. Instead, just eliminate the however. All right, so let's do that. Here, where is here? I don't know. Here, defendants misrepresent the law. What law? I don't know. You don't know. But the defendants are misrepresenting some law. We're not going to point you to a fucking citation about like here on this page when defendants say X, they're misrepresenting the law. The law is actually Y. See this case, this rule of FRCP, this local rule, whatever. What Judge Strickland may do, so it's permissive, not mandatory. He may evaluate the plaintiff's affidavit. He may also say, go fuck yourself. I don't know. So it's not just me, like, because this doesn't make any fucking sense. All right. So what he may do. So this sounds like whatever it is, whatever the actual test is permissive, not mandatory. So the judge may or may not. What he may or may not do is evaluate plaintiff's affidavit, okay, to see if it sufficiently puts facts at issue that could be evidence that reasonably questions the impartiality of Judge Strickland. But see, the facts that were put forward were basically Judge Strickland allowed these people to file things and ruled in their favor and denied the TRO and looked at the non-moving parties. He looked at the non-moving parties' opposition to the TRO and accepted those facts as true, which he can fucking do. He can fucking do that. He's supposed to do that. Well, not necessarily. I mean, anyway, he can do that. But that's basically what they're saying. The judge ruled against me, therefore biased. And what can James Springer put in an affidavit as a percipient witness that is going to put facts at issue to call into question Judge Strickland's impartiality? There's no fact that James Springer has that he could put in an affidavit. The things you could put in an affidavit, like, I saw this, I heard this, I smelled this, I tasted this. Not I think the judge was biased. That doesn't help anybody. That's, again, a conclusion. That's his opinion. It doesn't help anybody. Who, what, where, when, why, and how? What did you see? What did you smell? What did you hear? Well, according to Nord, getting a BJ while you're not standing up is also super gay. So I'm super gay. But, and again, why are we starting a new sentence with but? Just eliminate it. Let's just start here. If plaintiff has put sufficient facts forth, comma, to reasonably question the issue, comma, then the reasonableness question must be resolved by another judge under the statute. In this case, in this regard, Salt Lake Tribune, this case, cited by defendants but largely avoided for what the case actually provides for this process, is instructive because both Section 455 and 144 are invoked. Under Section 144, we're finally talking about the law. The District of Utah Court clarified that under 28 U.S.C. 144, the standard for recusal is higher, but the procedural requirements are different. Section 144 states to the judge, shall. That's not may, that's shall. Remember I was talking about may? He was talking about may, now we have a shall. The judge shall proceed no further in the case if a party seeking recusal files a timely and sufficient affidavit that the judge before whom the matter is pending has a personal bias or prejudice either against him or in favor of any adverse party. If properly pleaded, all the factual allegations in the affidavit must be taken as true for the purpose of the motion under 144, and the court decides only whether the affidavit is timely or legally sufficient. We've got a footnote mark here, no footnote. We've got a footnote mark here, no footnote. I don't like that particular source, so we're going to go different. We're going to go different. We don't have it on Google Scholar. Don't have it on Google Scholar? It's not on Google Scholar. I don't want it. Scholar. The Scholar action. Sometimes I forget you guys are even watching. I know that probably makes me a bad person. Probably makes me a bad person. X. We're going to go Control V. V. We're going to do federal courts, and we're going to Salt Lake. There we go. All right. So where was he looking at? He was looking at about page 1173. About page 1173. All right, so they moved under two provisions of the law, 28 U.S.C. 1444 or 144 and 28 U.S.C. 455. Neither provision provides for referral of a recusal motion to another judge, but if the issue of a judge recusing himself arises either through a motion to recuse under 455 or an affidavit of prejudice under 144, the judge has the option to either transfer the matter to another judge or in determining it himself. So let's look at this particular 28 U.S.C. 144. Whenever a party to any proceeding in a district court makes and files a timely and sufficient affidavit that the judge before whom the matter is pending has a personal bias or prejudice either against him or in favor of any adverse party, such judge shall proceed no further herein, but another judge shall be assigned to hear such proceeding. The affidavit shall state facts and the reasons for the belief that the bias or prejudice exists and should be filed not less than 10 days before the beginning of the term at which the proceeding is to be heard. Or good cause shall be shown for the failure to file it within such time. A party may only file one such affidavit in any case. It shall be accompanied by a certificate of counsel of record saying that it is made in good faith. So what did we fail to do? What did we fail to do? We failed to file this before the judge started hearing everything. My Modelo Chelada is gone. How many ounces was it? 24 fluid ounces. You know, don't I know it? Don't I fucking know it? 24 ounces, that would be what, three alcoholic beverages according to Coded? Coded can go fuck himself. Okay, so happy Friday, everybody. So what did he fail to do? He failed to file it 10 days before the beginning of the term at which the proceeding is to be heard. He failed to file it before the judge started making shit happen, right? So it gets assigned to the judge, and then he needs to file this motion in a timely fashion. Not after the judge has already made a bunch of rulings on the case, but before that. So that's where he fails like a motherfucker. No shit, you don't say, Michelle? Really? He fucking lies all the time. He lies like a goddamn rug. He just makes shit up all the time. I didn't mind it. Does my bladder need an award? Participation trophy? Well, there's one way for you to find out. Yeah. So there you go. All right. So I don't know why he's talking about 28 USC 144. Did he even move under 28 USC 144? Did he even move under 28 USC 144? Motion to disqualify. Here we go. I don't want that. I'm going to download it and open it. Download. And plus. Show this tab instead. 20. So he did ask for removal under 28 USC 144. Now, where does he show good cause for the late filing? Where does he show good cause? Where does he show good cause? He doesn't show good cause. He doesn't even plead good cause. Let me rephrase it. He does not plead good cause. And then here's the affidavit of Springer. We're going to see all the factual allegations that Springer made. I've reviewed the filings of this case with my attorneys. I've never been obstructive. Okay, so now he's arguing over the findings the court used. Great. I've never instructed to use any language. Okay. I was unaware. Okay. After learning the requirement. I was unaware of the mask mandate. My YouTube channel. It appears that despite filing and serving my case in mid-June, blah, 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 this isn't something that he has first-hand knowledge of. It is my understanding. Really? I specifically request. Yeah. So he has. So what he has to show is like. What he'd have to show is like. Judge Strickland is my neighbor, and he always yells at me because my dog shits on his lawn. And he doesn't like me, and we've had words before. That would be personal bias. Or I was at the bar on Friday night, and I saw Judge Strickland hanging out with Shannon Murdoch Poff, and they were having drinks together and laughing like old friends. And then I went on their Facebook pages, and they've both been friends forever. And you know what? They used to date. Boom. That's a 28 USC 144, right? That's just a 28 USC 144 right there, because you're showing bias. Like this is stuff like you've seen or heard or whatever. You have some firsthand knowledge of it. I've seen their Facebook pages where they say that they were dating. I've seen them at a bar where they were kissing. My dog shit on his lawn, and he came and yelled at me and told me that if I was ever in front of him, he would make sure that I lost. These things are things that you can, like, your senses, but nothing that Springer alleged in here. Like, none of this, it's all garbage. This is all garbage. He has not alleged anything in here that is a showing of personal bias. It's just, I lost, and therefore he's biased. So he loses, in my opinion, and you can tell me how dumb and wrong I am, he loses under 28 USC 144 because he didn't do it prior to the judge starting to make rulings, and he didn't show good cause as to why the judge should recuse himself later, as to why he didn't file it at the beginning. Because remember this 28 U.S.C. 144, because judges are going to get biased against one side or another in a case. That's how they come to make a ruling. Juries are going to get biased against one side or the other in the case. That's how they come to make a decision. We find in favor of defendant. Why do they find in favor of the defendant? Because all the evidence that was presented, all the testimony, all the documents, all the pictures biased them against the plaintiff. And that's why they ruled, or they found in favor of the defendant. It's not sufficient to say, oh, he ruled against me, he's biased. Thus, in the present case, the affidavit is timely because it is presented. Thus, in the present case, the affidavit is timely because it is presented. The clarifying event was the order to show cause directed solely at plaintiff to explain delay in the case, while assuming that no explanation was due from the defendants. That's a terrible sentence, but I can understand it. Now, why would the court have issued an order to show cause to plaintiff? Why? Well, it's because he already had a default judgment against the defendants. The next step is to get he had a default against the defendants. The next step is to get a default judgment. They've defaulted. You're not going to do discovery. They've defaulted. Proceed. They can't object. They can't throw any stones in your path. They can't stop you from proceeding. Show me your evidence. Let's get this done. Let's get this judgment. Either you're going to win at this point or you're going to lose. The defendants don't have any say in it anymore. Let's go. Like, I don't know why his attorney doesn't understand, why his attorney had a problem with this. I don't get. Dude, you've just about won. All you have to do now is present all this award-winning evidence. I think the problem is that they don't have the evidence. And they're hoping that they're going to get the evidence through discovery, which is always a fucking terrible place to be. Terrible place to be. Why is it a terrible place to be? Because you've got to give them to give you the evidence to convict them, to not convict them, but to make them lose. The best definition is if drinking causes problems in your life and you continue, that's alcohol. Yeah, I mean, the DSM-5 basically rates it that way. Like, is this causing problems? What kind of problems is it causing? Yeah, he just ignores that. Was not timely. Yep. And yeah. But you know what? You know what he didn't do, Michelle? He didn't show you where he got his definition from, did he? I'll bet he didn't. I don't watch his channel anymore. I can't fucking stand him. He was fine, his background noises, before I was paying attention, but he caught my attention. And then I started hearing him. And I'm like, oh, Jesus. No, he didn't. Fuck. This is my shocked face. He doesn't fucking back anything up. He just, all he does is he fucking talks and he talks and he talks. He doesn't back shit up. He's a shitty person, and he deserves shiz. I feel bad for Josh, but Josh is a big boy. Josh, do not fuck shiz. Bro, don't fuck shiz. That's all I'm going to say, bro. Don't fuck shiz. You can do better. Don't fuck shiz. She'd totally fuck you, but don't do it. Don't do it, bro. Moreover, the affidavit is sufficient because it confirms the facts already apparent from the recording regarding procedural irregularities and deference in filings towards the judicial defendants. What procedural irregularities? What deference in filings? Deference in filings. The court. What did the court defer to them for filing as? Filing. You know what Wallace was doing? He was mailing it into the fucking clerk, and the clerk was filing it for him. Deference in filings. What does that mean? You're an attorney. Use your words. Finally, on this point, on what point? Plaintiff's affidavit confirms and verifies the procedural facts contained in the motion. Why can't you just refer to the record? plaintiff read and verified the facts in the motion. He does not have to restate them in his affidavit as well, as the defendants erroneously argue. I didn't hear them arguing that. What they were saying is that all he's doing is he's saying that I lost, therefore the court's biased. Moreover, Section 455 is to be interpreted and applied deferentially in favor of the plaintiff here. Again, from Salt Lake Tribune. Under 28 U.S.C. 455A, a judge is required to recuse himself in any proceeding in which his impartiality might reasonably be questioned. Well, there's what you know what we didn't do last time. We were going to look at 25. That's just a, and 26 is also just a citation. Okay, but now we're going to come up here. Under this, judge is required to recuse himself in any proceeding in which his partiality might reasonably be questioned. 28 U.S.C. 455A. Okay. As noted by the 10th Circuit earlier in this litigation, 455A contains an objective standard which requires disqualification only where the reasonable person, were he to know all the circumstances, would harbor doubts about the judge's impartiality. This means the judge must recuse himself where there is the appearance of bias, regardless of whether there is actual bias. Where the question is close, the judge should recuse. But 455A does not require recusal based on unsubstantiated suggestions of personal bias or prejudice, which is all that Freeman has. Unsubstantiated bias or unsubstantiated suggestions of personal bias or prejudice. Everything that Freeman is saying, you found against me based on this fact. You found against me based on this fact. But I think these facts are true. And the court didn't believe me, the court believed them, therefore bias. And the court ruled against me, therefore bias. And the court made me, they issued me an order to show cause for not filing for a judgment after I already had a default. I mean, none of this would make a reasonable person suspect that the judge was not impartial. Doesn't make me suspect it. I went in and go back and watch the first video I did on this case where I read the complaint and I was like, oh shit, if true, this is fucking terrible. If true, they're fucking Freeman up. If true, they're violating his due process rights. If true. That was my position. And now I'm like, this he's got a shitty attorney doing a shitty job, making shitty arguments. And why trying to recuse a judge? Dude, you're going to fucking lose. Number one, you're going to fucking lose. And number two, now that you've tried to recuse the judge and failed, that's going to fucking prejudice the judge against you. Oh, fuck me. Conclusion for the foregoing. What a shit motion. Oh, Blair Dunn Esquire, you should be ashamed of yourself, sir. You should be fucking ashamed of yourself. Or Zach Cook, whoever wrote this shit motion. Oh, I guess it was done. Fuck. That was terrible. Terrible. All right, what else we got? Oh, that was bad. That was fucking bad. That was document 55. I apologize for everyone on that. That was fucking terrible. Reply to response to motion to stay the appeal. Ugh. Well, I've been on here for quite a while. It's dark. I'm cold. I think we're going to save documents 56 through 60 for tomorrow. Thank you for watching and have a great day.